So SQE2 Interim Applications Part 2 Revision Notes. When interim application should be made and the procedures of that. Number one of the key principles of the Civil Procedure Rule, CPR, is that the court proceedings should be dealt fairly, efficiently at a proportionate cost. This is known as overriding objectives under CPR 1.1. Let's quickly go through again. Before we jump to the next paragraph, we're just going to quickly rephrase this again. So one of the key principles of the CPR is that the court proceedings should be dealt fairly, efficiently, and at proportionate cost. This is known as overriding objectives under CPR 1.1. Because of this, the parties should not rush to make an application to the court whenever a problem arises. Instead of, they should try to resolve the issue with the other side by communicating and negotiating. Now, some of the application you still need court permission, but it is always handy that you negotiate and come up to an agreement with the other party beforehand. You quickly jump to the court, because most of the interim applications do not need hearing. So if you are already in agreement with the other side, then you can just quickly come up with go with the agreement to the court that this is our agreement. You probably don't even need hearing. So that's more efficient, because the court have lot to deal with. They have lot in a plate. So it's gonna save the time. However, if the other party does not come in an agreement, then you can go to the court with the interim application and with all the reasons the other party is not behaving reasonably. This is gonna give you a good chance at the hearing as well, that when you go to the hearing, and especially when it comes to the cost of the interim application, mostly the person who is making application becomes the applicant. It doesn't matter whether they are a claimant or defendant, but once they're making an interim application, whether it's a claimant or defendant, they becomes applicant. So normally the general rule is whoever is making the application will be also paying the cost of the application. However, the court has wider powers when it comes to the cost. So if the other party is behaving very unreasonably and you put before the court, then the court can make the other way decisions as well, but that's completely up to the discretion of the court. So let's quickly go back to the paragraph. Because of this, the parties should not rush to make an application to the court whenever a problem arises. Instead of, they should always try to resolve the matter with the other side by communicating and negotiating. If both parties can reach to an agreement, they can often avoid the time and expenses of asking the court to intervene. As I said, sometimes you still need court permission, but you can go to the court with the agreement. That saves time, and especially the hearing. Mostly interim applications need hearing, and some of them they don't. For example, if one party needs an extra 7 days to serve witness statement and the other party agrees, there may be no need for a contested court application. This saves cost for the both parties and allows the case progress more smoothly. The court expects solicitors to behave reasonably and cooperate wherever and when is possible. Making unnecessary applications can result in wasted cost and may affect the cost order later in the proceedings. Now let's quickly go to the next option, apply as soon as it becomes necessary. Don't leave it to the last minute. This is very important and very commonly tested in SQE2. So although the parties should try to agree the matters first, they should not delay if the court intervention becomes necessary. So sometime, I'm not saying, but sometime the other parties do the delaying tactics. So if you think that is one of them, then you should apply the court permission immediately. Although the parties should try to agree on the matters beforehand, they should not delay if the court interventions become necessary. Practice Direction 23A paragraph 2.8 states that an application should be made as soon as possible and as soon as it becomes apparent that it is necessary or desirable. This means that one party realizes that they cannot comply with the court order, require additional direction, or need court's assistance, then they should act promptly. So say for example you need extra 7 days to file a witness statement. You may be able to ask 7 days before to the other party that they may allow you an extension of time, or you might come up with an agreement. But if you have 1 or 2 days left, then you can ask them, but then you don't have time because you don't want to miss the deadlines and face sanctions. Then you should file an application, N244, very commonly used when you come into practice, to the court as well. And meanwhile, you keep your negotiations with the other side as well. You may be able to come up to an agreement and you may not need hearing. and court grants as such. If you go with an agreement, they grant otherwise as well if you have reasonable grounds. This means once the party realizes that they cannot comply with a court order, require additional direction, or need court's assistance, they should act promptly. Delaying an application can cause one of the followings: unnecessary delays to the case, increased legal cost, prejudice to the other party, and criticism from the court. Remember, you always want the court to be your side, and you always want judge to be your side. So it is always efficient that you keep them and don't annoy them by keep on unnecessary delays. Let's quickly go to a real life example. The defendant has been ordered to file an expert report by the 1st of September. On the 15th of August, the expert informs the solicitor that the report cannot be completed until the end of September because further testing is required. The solicitor should immediately contact the claimant to seek an agreement for an extension of time. If the agreement cannot be reached, the solicitor should promptly apply to the court for an extension of time. That's interim application, and you'll be using form N244. Waiting until the 31st of August would likely to be criticized because the problem was known much earlier. So this is always problematic, so do not wait till the last moment. Let's quickly go to the next paragraph, bunching interim applications. The Civil Procedure Rules, CPR, also encourage parties to bunch or combine interim applications wherever possible. This means that if there is already a court hearing listed, the parties should let me just quickly go through again. This means that if there is already a court hearing listed, the parties should, where appropriate, raise all outstanding procedural issues at the same hearing rather than making several separate applications. That is not cost efficient, that is not justly, and that's not proportionate cost. So the court says bunching interim application if you know there is already a hearing listed. So if you have any pending issues or where you need the court assistance or court permission, so you merge all the applications and do it all in one hearing rather than keep on knocking back on the door. That's not going to be good for your client, and your client not going to be happy because they will be paying all disbursements. Means they'll be paying your cost, legal cost will be going up, they'll be paying for the disbursement such as the solicitor's cost, barrister's costs, etc. And plus, remember, on the other side of the cost as well. So you need your client to be on your side, so they trust on you that you're working in their best interest. The purpose of bunching application is to reduce court time, save legal cost, avoid repeated hearings, improve case management, and comply with the overriding objectives. Instead of asking court to deal with one issue today and another one next week, the court prefers to resolve multiple issues together whenever practical. So let's quickly go through bunching interim applications again. The Civil Procedure Rules also encourage parties to bunch or combine interim applications wherever possible. This means that if there is already a court hearing listed, the parties should, where appropriate, raise all outstanding procedural issues or wherever they need the court assistance at the same hearing rather than making several separate applications. The purpose of bunching or combining all the application is to reduce court time, save legal cost, avoid repeated hearings, improve case management, and comply with the overriding objective, CPR 1.1. Instead of asking the court to deal with one issue today and one next week, you rather bring all the issues, bunch them together, and put all before the court at one hearing. Let's quickly go to a real life example, which is, in my case, is very handy. I normally deal, it really makes you understand what you're on about. A CMC, Case Management Conference, has already been listed for next month. The claimant needs permission to rely on an expert report. Remember, the expert report is normally for the assistance of the court. If you want to rely on the expert report, you need court's permission. So the claimant needs permission to rely on an expert report, an extension of disclosures, and a permission to amend particulars of claim. That means statements of case. So normally these three things are three different interim applications. But if you know that the CMC is already been listed for next month and you have three outstanding issues: number one, permission to rely on the expert report, which you need permission for the court. You need extension for the disclosures, that's also you need permission for the court. and permission to amend your particulars of claim, that means statement of the case, you also need court's permission. So you have three outstanding issues. Rather than making three separate interim applications with three different hearings, the claimant should issue necessary applications so they can all be dealt during the scheduled CMC. So that's one done. Now let's go for procedure for interim applications. Whenever a party wants the court to make an interim order, they must follow the correct procedure under the CPR. The person making the application is called applicant. It doesn't matter whether they, in actual case, they are the claimant or the defendant, but whoever is making the interim applications becomes applicant and the other person becomes respondent. The court will consider the evidence and submissions from both parties before deciding whether to grant the order or not. So let me just quickly glance through how to make the application. Number one, form N244. Number two, you need to state on the form that what order you are seeking. Number one, the form, correct form N244. Number two, what remedy or what sort of order you are seeking. Why do you need it? The legality, legal basis behind that, and finally, why it is do you think why it's not prejudice to the other party as well. So number one, now we're going to go through again. Step one, complete the application notice N244. As I said, most interim applications are started by completing N244, known as application notice. This is a standard form used in the civil proceedings to request an order from the court. The form tells the court exactly what the application wants and why. What must be included in N244? The application notice should clearly stating the following: who is making the application, whether it's claimant or defendant. The form identifies the applicant and confirms which party is seeking the order. This allows the court to know who is requesting the court's intervention. Number two, what order does the applicant wants? Now, applicant, again, I will repeat that applicant means the person who is making, the party who is making interim application becomes applicant. So the applicant must clearly specify the order being requested. Examples included an extension of time, permission to amend the statement of case. Statement of case means particular of claim, defense, or claim form. Rather than you, sometimes you do need to amend it. For example, during the disclosure stage, you merge with new evidences. So rather than bringing a new claim, you can ask court permission to amend the claim. So permission to amend the statement of case, specific disclosure, permission to rely on an expert report, summary judgments, and interim junction. The order should be precise so the judge knows exactly what decision is being sought. Number three, why the application asking for the order? Why the applicant is asking for the order. The applicant must explain why the court's intervention is necessary. This should include the facts giving rise to the application and why order would help achieve the fair management of the case. The explanation should be concise, logical, and supported by evidence where necessary. Number four, what information does the applicant rely upon? Now the applicant must tell the court what evidence supports the application. Depending on the circumstances, this may include a witness statement, a statement of the case, an affidavit where required, documentary evidence, or other relevant documentations. The evidence should explain why the court should grant the order. Always remember, when you make an application and you file the evidences along with that at the court, you also must serve the same thing on the other party as well, so they have a fair chance to review your application, and when they want to respond to that, they can respond to that as well. No surprises at any hearing or application. Court fee. Most interim application requires the payment of a court fee when form N244 is filed. The fee must actually be paid before the court process the application. The amount depends on the type of application and whether a hearing is required. Failure to pay the required fee may delay the application or prevent it from being issued. Let's quickly go through a real life example, putting all together. Imagine a claimant has been ordered to disclose all relevant documents by the 15th of October. A week before the deadline, the claimant's solicitor discovers that thousands of archived business records still need to be reviewed, making it impossible to comply it on time. The solicitor first contacts the defendant's solicitors to request an agreed extension. The defendant refuses. As it becomes clear that the court intervention is necessary now, the claimant promptly completes the Form N244 requesting an extension of time. The application explains why the extension is needed, including a witness statement describing the difficulties in reviewing thousands of documents which have been discovered during the disclosure, and the appropriate court fee must be paid. Application is then served on the defendant, who has the opportunity to respond. The judge considers both parties' argument and decide whether the extension should be granted or not. Not all the time it is necessary to for the hearing. Sometimes judge orders without the hearing as well, and sometimes the hearing is necessary. Let's quickly give you a practical tip for this exam. In this exam, advocacy or litigation station, always think in this order. Number one, can the issue be resolved by an agreement with the other party? If yes, always go for that. If not, the court application necessary. Has the application being made promptly? Don't leave it to the last minute. Number four, can any other outstanding applications be dealt at the same time? Bunching, combining all the applications. Again, what I said earlier, that don't keep on knocking on the court's door. It's not going to be good for anyone, and it's not going to be cost efficient either. And number five, has the Form N244 has been properly completed with the order sought, reasons, supporting evidences, and correct court fee. Following this logical approach demonstrates good litigation practice and compliance with the CP, Civil Procedure Rules. Okay, let me ask you a quick question. You can pause the video and you can answer it yourself, because I will answer after that anyway. The claimant realizes 3 weeks before the disclosure deadline that additional time is needed because important documents are stored off-site. The defendant refuses to agree an extension of time. What should the claimant do? So, number one, the claimant already approached the defendant and they refused it. Now, rather than leaving it to the last minute, now the court intervention becomes necessary. So they should fill up the N244 form, apply to the court straight away, reasoning why needed. As it says in the question, that 3 weeks before a disclosure deadline, additional time is needed because important documents are stored offsite. So these are the reasons why the order they're looking for extension of time. Number one, why they need it? Because they need to review more documents which are stored offsite. And legal reasoning behind it, obviously, is important for the case, and it can prejudice their side, so they must review it. So they put legal reasoning behind that if without this, the case will not be justly and proportionate injustice. So, and they also should mention this, that they have tried to resolve with the defendant, but they have refused it. Therefore, the intervention is necessary. So once they mention what order they need it, why they need it, and legal reasoning behind it, and then the fourth thing, they need evidences. So they need to evidence such as witness statement or anything else necessary. Even sometimes affidavit is required as well. And plus, final thing, they need to make sure the N244 form is filled up properly and the fees is paid. And then it will go to before the judge, and judge will decide whether to grant or not. They will also listen. When you're going to file it, you're going to serve on the defendant as well, and the defendant have a chance to respond, oppose the application, and then the judge can review both of them. Let's read the answer what it says now. The claimant should act promptly and make an interim application using Form N244. Before applying, the claimant has correctly attempted to resolve the matter by an agreement which encouraged by the overriding objectives. Since the agreement has not been reached, the claimant should explain the reasons for the extension of time, providing supporting evidence such as witness statement, pay the required court fee, and serve the application on the defendant. If another court hearing is already listed, which sorry I forgot it, then the claimant should add or bunch that as well where possible. Ensure that this application is heard at the same time as where the other pending matters where the court assistance is required to comply with the principle of bunching application. So that's all for the time being now. I will come back with you with the next topic very soon, and hope this helps. Thank you for watching. See you in the next video.